contracts. Just in case you aren't familiar with me, I'm David Steffen. You might know me as the co-founder and administrator of the Submission Grinder, which if you're not familiar with, if you're a writer, it's a donation-supported tool to help you track your submissions. You can find publications for your work. You can find response time statistics, track expenses, all kinds of fun stuff. I'm also the editor-in-chief of Diabolical Plots, which is a science fiction and fantasy webzine. I've been running that since 2000, or that started as nonfiction back in 2008. I've been publishing original fiction since 2015. I also edit the Long List anthology, which is a reprint anthology of works that are from the Hugo Award longer nomination list. And I started as a short fiction writer before all that. So I started in 2007 or so, and I got my first publication in 2009. So just to give you some idea of my background, that's in pretty much all those aspects, I've had something to do with short fiction contracts, whether I'm coming at it from the author side or the publisher and editor side. And also for the Submission Grinder, I read a lot of guidelines to kind of vet, try to make some decisions about like what I would consider acceptable behavior from a publisher and that sort of thing. So I look at a lot of publication terms from many different angles. So that's where I'm coming from. Just to kind of narrow down the scope of this a little bit, this is specific to short fiction. Novel contracts are totally different. I don't really have any experience with those. Poetry contracts are pretty similar, probably, but I also don't have personal experience with those. And as far as short fiction goes, it's just normal. You're submitting through a submission queue, as opposed to, say, media tie-ins. Media tie-ins are very different. By media tie-ins, I mean like if somebody hires you to write a Star Wars short story, the terms are very different. And so I don't really have a lot of experience with that. They don't tend to publish those. They're negotiated on a case-by-case basis. So just to kind of narrow down the scope a little bit. Okay. So first, share my screen real quick. Don't have a lot in the way of presentation, but just kind of some bullet points to kind of talk through a little bit. So yeah, so this kind of give us an idea of what we're all going through. So here's kind of an outline of kind of what we're going to talk about through the day. There will be some opportunity for Q&A at the end. I also took some questions via the registration form ahead of time. So I'll try to kind of fit those in as we go through it. But among other things, kind of the main topics we're going to talk about is what are contracts for, what to do if you have editors who don't want a contract, submission terms. I'm going to list a whole bunch of them, and we're going to talk about them in lots of detail. Submission terms is terms that you would have at the time that you submit, as opposed to contract terms, which would be what you would have when they send you an acceptance and they've decided to publish you. What to do if you see something that seems off, working on negotiating, advanced questions. So these are where I would answer the questions that people asked ahead of time. And then as long as we have time, I'll go through some example contracts and we can open up for Q&A. You can feel free to post questions via chat as well, and try to make sure that I see them, although the chat window's gotten a little small since I changed the presentation mode for me, so hopefully I see them. Just so you know, it looks like if you want to change your layout, you might want to change, there's some different layout things. If you show it in grid view, it might show me with a bunch of other people. But you can, there's some different views that you can experiment with to try to make me bigger on your screen if you need it. Okay, so let's get started then. So big question is, what are short story contracts for? A lot of times I think when people think of contracts, they think of avoiding lawsuits. And that's true to some extent. But really, it's not so much about lawsuits because generally in short fiction, there's not a lot of money involved. Like even a professional paying short fiction market is paying something like 10 cents a word, which for a normal size short story might be a few $100s. So it's low enough money generally that to get a court of law involved would probably end up spending more money than would be involved in the actual contract. But short story contracts are still important. Even if I've never been to court over one or had to deal with any kind of legal system over one, but I still would insist on a contract, generally whether I'm the writer or I'm the publisher. The main point of the short story contract is because you want to make the expectations clear of both sides. Both sides should be able to walk away after signing a contract and say, this is exactly what I expect, and know that there are limitations on what they're giving up. They're getting something in return, and what they're getting in return is very specific. And so it's very important for both sides to be clear what's expected. Otherwise, you can end up in a situation where, say a publisher, if there's no contract involved, a publisher reaches out to you and says, hey, I'd like to publish your work. You say, okay, cool, that sounds great. They publish it on their website. You walk away thinking it's great, and then later on you decide you want to reprint it, and then you find out that the original publisher is now like producing it in a podcast, and that might interfere with your reprinting, and you weren't aware that they were going to do a podcast and that kind of thing. And like in a lot of cases, it's not so much malicious behavior you're protecting against, although that is certainly part of it. It's also just kind of cluelessness. You want to make sure that everything that you're discussing is explicit, limited, and that you're aware of it. You're making an educated decision about it, so that you don't find out that somebody else is using it in ways that you didn't anticipate. Maybe they're using it to produce a film or something, and you really wanted to keep the film rights in case there was some kind of opportunity for that. And so a good contract will tell you exactly what rights are being consumed and in what time frame. It's very important to limit the time frame, especially because if there's anything that I want you to take away from these contract terms is to avoid your story ending up in limbo. You don't want to end up in a situation where your story has not been published, but you no longer have the rights to publish your own story. You spend a lot of time writing the fiction, trying to make it perfect, make it as good as you can, really try to make an impact on people. And it's really heartbreaking if you end up in a situation where you can't do anything with your own story. It's your own creation and you're stuck. And so limiting the time frame is a big part of that. So we'll get into some details on that later. Another reason that you might need contracts is to prove that so that the publisher can prove that they have the right to publish to third parties. That's really important. That's really important. Say, one of the things that I publish is the Long List anthology. That's almost all reprints. So one thing that I've learned is that some of the big ebook publishers, if you submit something to publish with them in an ebook, and they can find that text online, which is ordinarily the case with a big reprint anthology like that, then one of those ebook publishers or ebook platforms in particular will immediately send you an automated threatening email saying that you have 5 days to prove that you have the publishing rights. So you want to make sure that you have all those contracts arranged ahead of time so that you don't have to be worried that you're going to lose your account or something like that from a publisher point of view. So it's also good to have the contracts all lined up so that, if somebody demands to know if you have the publishing rights, you can say, yes, here's the contracts, I have the publishing rights, I'm allowed to do this. And a lot of this is just risk reduction in various ways. I'm a very risk averse people, and so it's fine to take risks, but I want to understand the risks that I'm taking. and I want them to be calculated. Like if I'm giving something up, I want to know what I'm getting back out of it, or what I'm at least having a chance of getting back out of it. So I like to think of a lot of it in terms of kind of a risk benefit, and having a contract reduces the risk significantly. So one thing that I've run into, which is a little bit odd, perhaps, is there's the occasional editor who says they don't want a contract. A lot of times I don't think this is from a place of malice. It tends to be like a one-person publishing press, where it's one person doing stuff in their spare time. They might have a full-time job and a family, and lots of other stuff going on in their life, and they're doing this publishing thing as a hobby. Maybe they're publishing it on their own blog or something like that. There's nothing wrong with any of that, but sometimes somebody who's publishing from that point of view can end up, they kind of see the contract as kind of unnecessary bureaucracy. Like, I don't want to deal with that red tape. This is a hobby. I don't want to deal with that. So it's, but they also need to keep in mind that the contract is there to protect them as well. If they have a contract with the writer, and the writer says, hey, this person published without my permission, it can become a copyright dispute, which if that went to court could be very expensive. But if you have something that both parties signed that shows I gave you the right to publish this, then it protects them as well. So like, from that point of view, they should really want a contract. It doesn't take that much time to handle contracts. And it's really beneficial to both parties. So in the cases where I've come across a publisher who didn't want a contract, one of the things, so I wouldn't necessarily say that you should never do that, but I would definitely make it is adding risk, because you have less control over what exactly is going to happen. And so I would try to make it as calculated of a risk as possible and try to consider it. Do you think that you're getting enough out of it to be worth the risk? Do you think, try to consider the worst case scenarios and what could happen in the worst case scenarios. One major thing too is, how well known is this person in the community, in the publishing community? Like, say one of the cases I can think of with this is the person was a very prominent science fiction author already. They had published novels. They were very well known. And they were kind of doing the editing thing as kind of a side hobby on top of all their major writing stuff. And so, like, in that case, I felt it was less risky, because the person has a reputation that if people found out that they were trying to take advantage of new authors and stuff like that, their reputation would really be harmed in the community. So just kind of weighing different things. But generally, I would still ask for a contract, and even in a case like that, I would see if they would be willing. Just a sec, I'm going to see if... Okay, it's just trying to get the chat window to come up so I can see if anyone had anything I needed to know. I actually stopped the presentation part. I don't actually have a lot going on for that. Okay, so let's talk terms. So before we get to the actual contract, I wanted to point out there are actually there's some terms in submissions that you'll have to deal with that happen even before the contract. So there's these are things that would be in the guidelines themselves. So normally, when you're getting ready to submit to a place, you go to their website. There's a section called submissions or called guidelines. For short fiction, a lot of it's actually up front. So most of the time, they'll give you the word count limits. They'll tell you how much they're willing to pay. They might say the period of time that the contract lasts, some other terms like that right up front, which is really nice, because that's not true in a lot of other publishing contexts. The media tie-ins, they don't generally publish those ahead of time. Novel contracts, a lot of times you have no idea what you're getting into when you get into that. But short fiction, a lot of times the terms are kind of upfront. And so, like, especially say for the pay is almost always upfront. And so if you don't want to get paid as little as they're asking, then you generally just don't submit. And so that simplifies things in a lot of ways. There are sometimes statements also in the submission guidelines that state what you're agreeing to by submitting. So you want to keep a very close eye on those, because some of those can be red flags. There's some that are not red flags at all. There might be terms like, you agree that this is your own writing. And so that's very reasonable. No publisher wants to get into a situation where they've published something that's been plagiarized, where somebody is submitting writing that was written by somebody else. So putting that term in the guidelines, I mean, people should know not to submit plagiarized work anyway, but just formalize it a little bit. And there might be other things like, you agree that it is not libelous. Libelous is when you put something in writing that disparages another person in real life. It's obviously not usually a problem in fiction, because you're supposed to be making things up. But say if you had a coworker and you named somebody in the story after your coworker and used their exact name, and then had the character be super annoying or a terrible person or something like that, then that could come up. I would generally not recommend naming somebody after somebody in real life, because you're going to get into trouble unless they're in on it, or you have some kind of Tuckerization reward for a campaign or something. And then one red flag that I would definitely completely avoid, if you can, is I've seen some publications that say, by submitting, you agree to publication. Personally, I consider that a complete no-go. I would not submit there at all. And in the submission grinder, for instance, that we've chosen to make that the publication doesn't get a listing if that language is in their guidelines. And the reason for that is that it doesn't give you a lot of control. You generally can't negotiate something like that because it's in the guidelines. By submitting, you're supposedly agreeing to it. Whether it would hold up in court or not, I don't know, but it's kind of one of those things, again, that trying to contest it in court would be expensive, probably. And it's better generally to avoid trying to, even if you think an agreement is not valid, I would still avoid trying to enter an agreement just because you think it's invalid and could be invalidated, because you're taking a risk and it could be expensive to prove. And so the reason that that's risky is that you don't have any of the other contract terms that you really need, such as the limitation of how exactly they can publish it, what the time frame is, that kind of thing. So you don't have, you're missing everything in the contract that you really want. It's not setting those expectations. And like, you might not even know if they've read it or not, and they might, by that term, they might agree, or they might publish it without you even knowing about it, because according to those terms, you've given them the rights to publish. They don't need to talk to you to be able to do that according to those terms. So like, and I don't think it's a very big, it's not a very high bar to set to say that they need to talk to you to be able to publish your work. I would say that in the bare minimum of communication between an author and a publisher would be 3 parts. For a general, like, author is submitting things to an open window kind of thing. Part 1 would be the author submitting the story saying, I would like you to publish my story. Part 2 would be the publisher replies to say, we would like to publish your story. Here are the terms that we would like to do it in. And then the author would reply to say, yes, I'm on board with those terms, sign the contract, etc. So anything that doesn't require those, at least those 3 steps, I would be very skeptical of. And again, I would personally not submit to anything that said that you were agreeing to publication at the time of writing, even though, of course, you'd be very excited to be published at a place. But, you still want to be able to control those terms. So, okay. Presentation again, I guess. Okay, so let's talk about some typical contract terms. And later in the presentation, I have some actual sample contracts we can look at, so we can kind of break it down into these separate areas if we want at that time. But thought I'd just kind of talk about some of the particular things that we'd be looking into here. So first is a lot of times you'll see language like first publication or reprint. So this is just whether it has been published before. A lot of times there are many magazines and things out there that will publish reprints, which means that it has already been published and they're aware that it has been published. And so a lot of times it'll be a lower payment amount, and some of the other terms might be slightly different. But the difference is whether or not it's been published before or not. So a lot of times this will be tied into some of the other terms. So it might, especially these first three lines here. So a lot of times you might say the first audio rights, or the first North American printing rights, or something like that. A lot of times in this online world, the region doesn't really apply because anything on the web is available pretty much anywhere in the world. But it does apply in some, like if you're doing printing things, you might be only selling like UK printing rights or North American printing rights or things like that. And again, it would probably have the first applied to it if they're expecting this to be the first place it's ever been published before. Otherwise, it'll say something like reprint. Media is another important one. Media could mean that it's like published online in a blog, it's published in an ebook, it's published in audio, and then and each of these might be split down even further. So in audio, it could be an audio book, it could be a podcast, it could be various other things. There's some things that one thing that doesn't usually get counted as like a first right as far as most of these things go is a public performance. So that's something to keep in mind. So like say if you go to a convention and you read your story out loud at a convention, that's generally not considered to take up any publication rights or any publication rights that matter, unless it's recorded and displayed elsewhere, say on a website later. That might be a case that you want to ask about. So if I were, say, doing a reading at a convention, I would want to make sure that it's not recorded or that it's only recorded. You'd want to ask about that ahead of time. Most conventions are pretty good about that, so that you can only see it if it's live, in which case it's basically equivalent to like a public performance. So that's something that you definitely want to keep in mind. But for media, I would generally try to, in the contract, I would try to keep it limited to the media that they actually expect to use. So like some especially newer publishers might say something like, we want to publish it in an ebook, and maybe sometime down the road, we want to publish it in a podcast. I would generally resist that to the extent that you can, because if their plans are so vague that they can't even say whether they're pretty sure they want to do it or not, then in general, I would probably ask them to make a separate contract for that at the time that they were thinking of using it, or at least to put a time limit on it. So we'll get to the timeframes a little bit later, but like I would be very wary. The broader the language is, the more wary I would be. So if they say, we want to publish this around the world in every media format for the rest of time, then I would be seeing red flags all over the place. Oh yeah, and Sislin just popped in to say Flights of Foundry specifically doesn't record readings for just that reason. So that's perfect. So then another thing here is exclusive versus non-exclusive. So exclusivity, this is generally applied to first publication rights. I have seen it in some particular reprint rights, so I'll get into that in a minute. But exclusive means whether or not anybody else has the right to publish it. And so generally, if it is exclusive, the exclusivity has a particular period of time. So for instance, if somebody publishes a new story with Diabolical Plots, it has a 6-month exclusivity period in it. That means that, and we only publish original fiction. So that means that if they've submitted it, by submitting it, they're declaring that it has not been published before, and then there's some time between acceptance and contract and publication. They can't submit during that period, or they can't publish it elsewhere during that period of time either. And then after the time that Diabolical Plots publishes it, they can't publish it anywhere else for a period of 6 months after that publication date. You can see different timeframes for these for short fiction. A year is pretty typical. 6 months is kind of on the shorter side. Shorter is obviously friendlier to authors because they can submit it elsewhere for reprints. But it's not unusual to see some kind of exclusivity period, probably usually less than a year or less. Occasionally might see 2 years. If it's, say, longer than 2 years, I'd be a little suspicious of it. I've seen some places that ask for 5. 5 is just seems like a really long period of time, especially since with people reading fiction online, the attention span's pretty short anyway. So I don't think it's really interfering with anything for it to be published sometime not too long later somewhere else. If you're a writer, reprints are a great deal because they help you reach a new audience. Big new audience, might be able to get paid some more money, though not all reprints pay. And so it's something you definitely want to take advantage of as a writer, but you want to make sure that you're doing it properly, which means, in this case, mostly paying attention to the exclusivity period. So in that case, say with Diabolical Plots, you wouldn't want to submit it anywhere else until after that 6-month period, or at least maybe you want to submit it somewhere else, but with the understanding of that it won't be publishable until after that 6-month period. So it's not actually telling you can't submit it, but it's telling you that you can't publish it. And so personally, I would wait to submit it at all until after that period. But if you knew that a particular anthology always had a 6-month period between the submission window and the publication, then you could just be upfront with them when you sign the contract with them to say it's not available for publishing until a particular date, that kind of thing. Okay, so another thing is copyright. Copyright is very important. It's something anytime that a contract mentions copyright, you want to read that part very, 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 very closely, because some different wording in phrases involving copyright can mean that you lose the right to publish your own work. So this can be a major issue, and there are even some major publications that actually ask for copyright. And personally, no matter how big the publication, I would still be very wary of it unless it's some kind of dream of yours to be published there. But then just keep in mind that with the copyright also tends to come with a bunch of other things such as derivative rights, things like that. What if you give the copyright away or sell the copyright, then that could allow somebody else to make sequels with the same characters. It could allow them to make adaptations in any kind of media that they want. They can make a movie out of your short story without giving you credit, without paying you, without etc. So copyright is something you want to be very protective of. And in general, I would say that you shouldn't need to give up copyright at any point. I've seen some guidelines where they say, copyright will transfer to the publication and then will transfer back to the author at the time after it is published or something like that. And I would be very wary of that. I would make sure that the contract is very specific about what it means by that, and I would try to get it reworded so that it doesn't require copyright transfer, because that's not actually needed. A publisher does not actually need your copyright to be able to publish your story. They just need first publication rights or reprint publication rights or whatever. They don't need the copyright. At the time that you write something, it is already protected by copyright at the time that you write it. You can pay some extra money to have that copyright officially registered, but it is officially yours at the time that you write it. And generally it should always stay in your own ownership. So this is one area where like the media tie-ins are very, very different. Because say if you write a short story in the Star Wars universe, you generally will get credit for writing that. Like your name will be on the book or whatever, but you don't own the copyright in that specific case. And that's generally considered okay because the owner of the source material, the media tie-in, they have more control in that situation than in a typical story where you're making your own stuff. And so they want to make sure that, they control what is considered canon. They don't want you to be able to write whatever you want. You have to authorize it with them, and etc. So the media tie-ins, the copyright situation is very different. I would also generally expect to be paid pretty well in that kind of situation. But that's an area where they're very, very different. So giving up the copyright if you're writing a Star Wars book is maybe different. So I would talk to somebody before you did something like that. I would definitely talk to them talk to them about that. Just a second, I gotta figure out how to bring the chat up. I saw something. Legal name, not their pen name. Do pen names make this more complicated? Not necessarily. Generally, the copyright is under the pen name. And that's pretty important because that's the name that would be on the cover of somebody's book or whatever. One thing that I guess I didn't get into here is that I can get into now that that question came up is generally in the contract, you might have multiple names listed in the contract under different contexts. So some possibilities are if you write under a different pen name than your legal name, there could be a section of the contract that specifically says this will be credited to, the pen name, Joe Blow or whatever. But then generally the contract itself, you'd be signing with what you consider to be a legal name. So at the bottom of the contract, you'd be signing with that legal name. And a lot of times, like at the top of the contract where it defines who the interested parties are, so it'll define like a publisher entity and an author entity. A lot of times that will be the legal name, but then there will be a separate section that'll say what the person's pen name is or whatever. Also, other things to consider for that are depending on where you live, there are different kinds of business entities you might want to consider that might make some of the contract signing a little bit easier along those ends. One of them is called a DBA, which is called doing business as. It gives you another name that you can use for like legal contracts. And that name is registered somewhere officially so that people can know, like, I'm doing business as Diabolical Plots or whatever. There's also different kinds of things like I know some authors register an LLC for their name. LLC stands for Limited Liability Company. The purpose of a limited liability company for a context like this is that it somewhat, as the name suggests, limits your liability. So like if somebody did end up suing you, it limits what resources are available to be, like if you came out badly in a lawsuit, what kind of resources you would have that would be vulnerable to that lawsuit. LLCs are a lot of times a good idea. I don't think there's a lot of major drawbacks, but one major thing you want to check is that I don't know what the context is outside of the United States, but in the United States, the terms for an LLC are defined by the state, and the terms are very, very different. And especially in terms of money. So like say in Minnesota, you can register an LLC. It's I think it's less than $300, and it's a one-time fee. And then you just have to fill out paperwork every year after that. But that paperwork doesn't cost any money. You just have to submit paperwork that says I am still doing this thing, and that's all that you have to do. I've heard that, say, in California, I've heard that the LLC laws are make it very expensive. So before you do that, you definitely want to look into what it would cost, whether or not it's worth it for a bunch of short fiction contracts. If it's a one-time cost of $300, sure, that would be one major short fiction sale could be equal to $300. So, that's not a bad idea. But if it costs you thousands of dollars a year, probably not worth it unless, you're super prolific in making a lot of sales or something. Okay. Oh yeah. And so anyway, for the names, in that case, the parties at the top of the contract, you could put an LLC name. So like when I do a publishing contract, at the top of the contract is Diabolical Plots LLC, and then at the bottom of the contract, I sign my own name because I am a representative of the LLC that's entering into the contract. Okay. So moving on, another question is alterations. So by that I mean alterations to the text. So who is allowed to make changes to the text? And normally that should be a collaborative effort. Normally I would say that the author needs to be involved for alterations, except perhaps for some very minor like formatting changes. So like say if I'm publishing a story and like my blog uses, or I publish it on a blog and the blog always uses Times New Roman font or something like that, and it was submitted in Arial, that's what I would call a minor formatting change. That doesn't need to be approved by the author generally. I mean, obviously, if you put it in something ridiculous like Wingdings or something, it'd be different. But a readable font shouldn't be a major issue. Like whether a paragraph is indented, those conventions change depending on whether you're in an ebook or whether you're in print or whether you're on a blog. So those are the kinds of changes that I wouldn't expect an author to need to be involved in. But pretty much anything else, I would say that they should. I've seen some contracts that say that they can fix minor typos and things like that, or grammar errors. I would personally not want to sign that if it said that, because what if my grammar errors were intentional? What if they were dialect? If it's dialect, it's not a grammar error in that, like that. If that's how the person is actually speaking, then it should not be corrected. And say like, I've published stories like say, and think like Flowers for Algernon, if you ever read that one. Like that one has intentional grammar errors in it because it is a characteristic of the character at the beginning of the story. And so if an editor corrected those grammar errors, it would make the story less true to what it was trying to be. Yeah, and so and I have been burned by this one before. So I published, I had a flash fiction short story that was it was kind of in a comedy flash fiction anthology, and the contract in that case said that the editor could make changes. And I had my misgivings about it, but it was a fairly large, well-known entity, and I was nervous about trying to make negotiations. And I signed it, and I regretted it because I didn't find out until I got my print copy of the anthology in the mail that they cut off the last 3 paragraphs of my story. And so like the story was kind of a mixture of, it was kind of melancholy, but also kind of funny. And like, it took a major turn in the last 3 paragraphs where it was like, before the last 3 paragraphs, it was kind of seeming like a downer, but then it kind of has a hopeful note in the last 3 paragraphs. It just chopped those off and left them off entirely. And so it ended up becoming a pretty bleak story instead of having a hopeful note at the end. Absolutely hated it. To this day, it's the only story I've had that has appeared in a bookstore like Barnes and Noble, and it really makes me sad that I don't want to recommend that book to anybody because I hate the way that it turned out with them cutting the ending off. So I definitely say that you want to keep control of the alterations. That does also mean that you kind of have an obligation to be responsive. So if they send you edits, hopefully they'll give you some kind of time frame. You should reply within that time frame. Try to reply as promptly as you can. That way they're not tempted to try to move on without you. You want to be as responsive as possible. And how to do edits is maybe a whole nother conversation, but I would say that it is your story. And so if they want to make changes that you don't like, say no. you can say stet. Stet is kind of the classic thing that you say to editors, meaning that let it stand. Like, I want to keep this thing the way that it is right now. But you should also listen. If they have suggestions and you like them, then you should go ahead and do them. But you should be involved is the point for the alterations. Compensation, amount, and time frame. So again, the compensation for short fiction is a lot of times declared up front. So if you didn't like the compensation that they had in their guidelines, you shouldn't have submitted. And so, it's not reasonable. I would not consider it reasonable if they had the compensation listed in the guidelines for you to ask for more compensation later, because you were submitting based on the premise of the compensation that they provided in the guidelines. So as long as they're still offering you the same amounts, I would say that you should really probably stick with that. If they want to offer you more, sure, why not? I mean, why would you complain about that? If they want to offer you less, though, I would say this isn't what I was agreeing to at the time that I submitted. You should offer me the amount that was in your guidelines when I submitted it. So I would definitely stick to that. Another thing they might say, and that is time frame. Sometimes a contract might say you'll be paid within, say, 30 days of signing this contract. That's probably about the most friendly one you can see, where it's based on the contract signing date, because a lot of times there might be a significant period of time between the contract and the actual publication. So signing it within a period of time of the contract generally means you'll get paid soon, much sooner. And but you might have other ones that say, like, it'll be paid before publication, or it'll be paid within 30 days of publication. All of those are generally fine. I would generally consider it friendlier to the author the earlier it is, though, because then there's less risk. They're getting their money. They can spend it on their bills or whatever else they need the money for. They're not waiting around. You're taking a little bit of risk, say if it says within 30 days of publication, because then what if they publish and then they don't pay you? Then you've already given up what you've given up. Most of the time, if it's an established entity, I wouldn't worry about it too much, but like, it is friendlier for it to be earlier, so something you could ask about at least. Time frame for publication. So this would be something like Diabolical Plots will publish this within 1 year of signing this contract, or 18 months, or 2 years. And so generally this will come with some kind of expiration of terms. So it'll say something like, if the story is not published within 2 years, then all rights will return to the author, kind of thing. And it might, so the idea there is that this is a really important one. This is one that I would absolutely insist on. I would not sign any contract that does not have a time frame specified, because this is where you're going to be most likely to end up in some kind of limbo, where you don't have the right to publish your own story. So say if you had a story or if you had a contract and the contractor said the publisher has the right to publish, and then there's no time frame. So just consider the worst case there. What if the publisher closes? What if the publisher stops responding to your emails? What if they do respond to your emails, but they still don't publish the story? If you don't have some kind of time frame there, then there's no clear expectation on when you can expect them to publish it. And like, say that exclusivity period, like that exclusivity period generally starts at the date of publication. So if they never publish it, that period never even starts. So that's something I would definitely insist on. Reasonable timeframes for something like that is usually, I would say, within like a couple years, probably. That's generally a little longer than like the exclusivity period, because it does take some time, depending on how many staff members and stuff. It does take some time to go through edits. They might need to slot it into the schedule. It might need to, if they have like a holiday story, they might need to, maybe they sign a contract in November of this year for a Christmas story, but they already have a Christmas story for this year. It might need to wait till next year. Things like that. There's a bunch of different reasons why it may take a little while to publish the story. But at the end of the day, there should be a time frame. And Ideally, that time frame should just end automatically. I have seen some where where there's a time frame where they say after 2 years, the writer can contact the publisher in writing to revoke their or to revoke this contract, things like that. Generally, it's better for it to just be an automatic expiration, because what if you can't reach the publisher? What if they close? What if the publisher dies? Um, what if they just ghost you and stop responding? I mean, these are all worst cases. You don't run into it too often, but you don't want to take that risk. So if you have an automatic expiration, then it's completely unambiguous that this story will return to you after this period of time, even if you can't reach them. And like, say if something like that did happen, let's say that the publisher had some kind of health issue or something that delayed it and they weren't able to publish, and they still wanted to publish with you after that period of time, that's fine. They would just need to contact you. They would just need to contact you and say, hey, I would like to publish this story, but I see that our contract expired. Could I go ahead and publish it? And, you know, in most cases, especially if they had a good reason for the delay, you might say, yeah, go ahead. We don't need to, you know, we can do a new contract, but the contract has the same terms as before. You don't need to pay any additional money or whatever because you already paid it. You know, so, but but you know, if there's something that the contract, if the publisher ever wants to do something outside of the contract, that's fine. They just need to talk to you and arrange a new contract. They would need to arrange some kind of new agreement that would cover whatever they want to do. And that would really apply to anything that we've talked about here. So if they later decided they wanted to make a podcast of the story, then they would need to talk to you and they would need to say, I would like to make a podcast. Let's have a new contract for the podcast. You know, and depending on the situation, you know, maybe they'll offer you more money, maybe they won't offer you money, and it's up to you whether or not you want to take it. With compensation, back to that for just a second. Whether or not you can expect to be compensated depends a lot on, you know, how well established the market is, what genre you're working in. Say in science fiction and fantasy, it's generally expected that publishers will pay something, but you do see some that don't pay anything. But there's in other genres, like literary, it's more frequent for there not to be any compensation, or also for the compensation not to be declared upfront, so it's a little bit less transparent in a lot of ways on that side. In a case where a publication offered to publish something of mine without compensation, I would definitely consider what I'm getting out of it, whether it's worth it. If they're a really big publication and they have 1 million readers or something like that, you know, maybe you can reach a lot more eyes and ears, and maybe it's fine for you not to be compensated. But that's a choice that you need to make, whether or not it's worth it. If it's like one guy running a blog that 2 people read, and he's not going to pay you for anything, then, you know, at that point I would be asking myself, why couldn't I publish it on my own blog and try to build an audience instead of giving it away to somebody else for nothing? So those are the kinds of things I think about when I'm doing contracts. Okay, so we already talked a little bit about plagiarism, in that that tends to be a term that they ask you for in the submission guidelines. A lot of times it will also be in the contract, which, you know, makes sense. It'll say something like you declare that it is your own writing, and a lot of times it will also protect the publisher if you're lying. If you sign this contract under false pretenses and you stole this work from somebody else, it'll protect the publisher from direct liability generally. So because you're the one who, if you submit something that's plagiarized, then you're the one that's responsible, and you entered into this contract under false pretenses. So this kind of helps protect the publisher in this case. Obviously, you shouldn't submit things that are plagiarized. It's bad practice in a variety of ways, and you want to write your own work, and then you can get your own work published. Libel is kind of another thing where the publisher's kind of covering their bases there. So that's, again, if you wrote a coworker in with their exact name and said some bad things about them, then they might get mad and sue about it, that kind of thing. And, in a case like that, the publisher wouldn't know your coworker, and so they might not know it's a real person, and so they need this part in the contract to protect themselves. That way, if there's any kind of libel lawsuit, it would be the author that's getting sued in that particular case, because they'd be the only ones who would know that this was libel in the first place. So, you should generally try not to libel, and in short fiction, it shouldn't be hard not to libel. At the very least, you can file off the serial numbers, change the names, change the circumstances enough so they're not entirely obvious who you're talking about, and things like that. And then obscenity. So there are obscenity laws. This is a weird one in that it's not really clear what obscenity means in a lot of contexts for, like, say, fiction, because, like, obviously people publish things that some people might consider obscene all the time, but it's like, who's deciding this? But one thing that I would push back against personally is if the contract says the author declares that their work is not, say, plagiarism, libel, or obscenity, and that the publisher is free of blame or indemnified of blame in these cases. So for the cases of obscenity, I would ask for that to be removed, because if a story is obscene, whatever that means, if a story is obscene, it's obscene based on the content of the story, right? And the publisher chose to accept that story based on the content of the story. So they're aware of the entire context of the story. And so if anybody's to be blamed for a story being obscene, the publisher has to share that blame, because they're the ones who decided to publish it. I haven't generally seen anything involving this. I'm not even sure what obscenity would mean in a modern context. Like, say, erotica and stuff gets published all the time without any kind of obscenity lawsuit that I'm aware of. So I'm not even really sure what this means. In like a legal standpoint, what would be the precedent here? But generally, I have pushed back against a publisher declaring that they're not to be blamed for obscenity, because, again, the publisher chose to publish the story out of the slush pile. So they've got to be responsible for the content of the story, just like the author is. And then kind of the last one here is arbitration. So this would be, if you had some kind of dispute, how is that dispute resolved? So they might mention that it has to be resolved in arbitration rather than being resolved in court, or various things like that. I don't know what all the different options are, but there might be language saying what happens in the case of a dispute, that kind of thing. Okay, and then I'll talk about a different kind of contract term just for a moment. I won't get into too much detail because there's lots of documentation out there. But especially in podcasts, I love publishing in podcasts. It's so much fun to hear somebody else read your writing in their voice. It's surreal and so much fun. But a lot of podcasts use a Creative Commons license. Creative Commons is it's a type of, it's not a, Creative Commons isn't one thing. Creative Commons is a whole category of kinds of contract terms that you can use for making it easier to define how something is shared. So, say, a lot of the podcasts that I've published at have something like a Creative Commons attribution, non-commercial, no derivatives license. So all of the important parts are right in the name there. There's also a website that you can look them all up. If you just Google Creative Commons, you'll find it pretty quickly. But say, in a case like this, it makes it so that you can share it like a podcast, and that's basically the root of it. Attribution means that when you share it, you have to say where it came from. If you say non-commercial, that means that nobody else besides the maker of the podcast can make money for it. And no derivatives mean that nobody else can alter the individual episodes of the podcast. So the idea around that is that, like, if the publisher puts up a podcast, I can download it. I can host that podcast episode on my own website for other people to download. That's all completely allowed, but I can't charge money for it. I can't claim that it's mine. and I can't make alterations. I can't cut the episode in half. I can't cut off the intro and the outro and distribute it. So that's just kind of a common thing. You see it a lot in podcasts. It's generally not something that I worry about because it's kind of necessary for the format that they're using. But it has some terms in it that sound a little weird if you're coming at it, say, from an ebook kind of standpoint or like a blog kind of standpoint, where you're generally not allowed to take something and redistribute it. Podcasts are kind of a weird corner case there, but it's all just to make sure that the podcast can get shared around the way that the you as the author would also want. Okay, so anyway, so these are a lot of the oh, sorry, I had a couple of things to go back to here. So one thing that I see in some contracts, it's fairly rare, but it is something I see occasionally, is I have seen contracts ask for your social security number. It always catches me off guard. It always strikes me as super weird. But just to explain that a little bit, so at least in the United States, I don't know if there's an equivalent to this, asking for this in contracts involved in other countries. But in the United States anyway, the Social Security number is it's an identifying number for each individual citizen, and it's something you generally don't want to share in places where you don't have to, because it can be a component in somebody trying to do identity theft, or to try to, say, open a bank account in your name, that kind of thing. All kinds of different things that you don't want to share your Social Security number in. However, one of the things that a Social Security number is needed for is if you have like a 1099, there's some tax forms that require it. And so especially if like a 1099, if a publisher pays you more than $600 in a calendar year, in the United States, I don't know what the laws are in other places, they're actually legally obligated to issue you a 1099 that declares this freelancer income, and then you're supposed to take that 1099 and declare it on your taxes and everything. Well, that 1099 involves some kind of tax identification number. By default, your tax identification number is your Social Security number. And so if they pay you more than $600, then they actually are legally obligated to ask you for that in order to be able to fill out the proper tax forms to distribute to you. One thing I would note, though, is that it does require $600 in a calendar year. And so if they're paying me much less than that, I would just ask to not include that. If you're making more than $600 for a short fiction payment, that's a lot. The standard, at least in science fiction, is like 8 cents a word. You need a lot of words to get up to that amount. If you're selling novellas or something, sure. If you're selling shorter fiction, though, you usually don't reach that threshold, at least at this point. But one alternative to that, though, is kind of come back to the LLC, the limited liability company that I mentioned earlier. If you have an LLC or something like that, I'm not sure if you can get this for a DBA, but it's something you could investigate. You can apply for an EIN, which is an employer identification number. So I have one of those for my LLC, even though I don't employ anybody. I have some volunteers who help out. But I don't employ anybody. None of them are legally my employees. So in that case, you can use the EIN in place of the SSN. And I prefer to do that because then I don't have to put my SSN on any contracts, because, if that document went astray, you're taking some risk that somebody would use it for bad things. And then one mention, talk about submission fees just a little bit. Those aren't the main topic here because, again, this is more about after acceptance for the most part. But some publications do charge submission fees. In science fiction fantasy, it's generally discouraged because what they call a Yogg's Law, which is that money should flow toward the writer. But there's other kinds of fees that a publisher might try to charge you. And I would definitely push back against some of them, especially
Some might try to do an editing fee. For instance, I've seen that some places where they say, we'll edit your story for you, but you have to pay us for it. I would not sign any kind of contract that allowed that. I would not pay any money for editing for a publication that's going to publish you. Just to be clear, I mean that to be entirely distinct from paying a freelance editing service to help polish up your story. That's different than a publisher choosing to publish your story and then charging you money. So, because like say, especially if you're doing self-publishing things, it probably makes sense to at least to pay other people, pay somebody to copy edit your story or something like that. But that's because in that context, you are acting as your own publisher, in which case you are incurring publisher expenses during the process of self-publishing. But in a normal situation where you're submitting into a submission queue for a publisher, if they ask you to pay them money to edit, I would not. I would just walk away. Because, one of the things you have to consider is with these contracts, like a publishing contract like this should really be mutually beneficial. You are getting something out of it. They are getting something out of it. You've agreed what those things are that each of you is getting out of it ahead of time, and you've agreed to it, and hopefully it should be mutually beneficial. But the problem with editing fees is it introduces a conflict of interest in that if they get, like say they get paid a certain amount for every round of editing, then they're incentivized to draw the editing out longer than it needs to be drawn out. And so they can just keep on looping and looping and looping and getting paid more money and not actually publishing your story. That's not to your benefit. So that's not something that you want to get into. Well, in a normal situation, there's some editing involved because you both want the story to be as good as it can be because it reflects on both of you, whatever gets published. But you want that to end at some point. You want to be done with edits at some point. They shouldn't last forever. There shouldn't be an incentive to make them last forever. Okay, so what happens if things don't go smoothly? What happens if you see something in the contract that you don't like? You see a red flag, you see an editing fee. They offer to pay you less money than they originally said they were going to pay you. They don't have a time frame on expiration of rights not used, that kind of thing. So again, I would go back to the idea of this being a transaction. Both sides are supposed to be getting something, and I would approach it from that perspective. And I would also talk about kind of the worst case scenarios with the publisher, like what if this thing happened? What if you got sick and you weren't available for emails for a period of time or whatever? Just kind of talk through some of the scenarios with them. Or if there's some language that seems kind of funny, but you're not sure, I would ask them for clarification. Like, what do you mean by this? Can you please explain this further? And then, you can also ask about changes. Short fiction contracts are generally not written in stone. There are things that can shift based on the author preferences, and it's always worth asking. Another thing to keep in mind is that you're not alone. There are other writers who have probably signed that contract or been offered that contract. And even if there aren't, even if this is a new publication, there are other writers out there who will take a look at your contract. So if there's something in your contract that you think is weird, that you're not sure you want to sign, if you have a friend who is more experienced than you in that area, I would definitely ask them. I would run it past them. Even if you don't have a friend, though, there are people who would offer to take a look at contracts. I'm one of them. If you want to reach out to me on Twitter, or you can reach out to me on the contact form on the Submission Grinder. Just to, and you don't have to share the whole contract. Just like, you can remove any identifying information from it. Yes, and the Dream Foundry Discord is also a resource for talking over contract terms. That's definitely a good resource. So if something seems fishy, I wouldn't just sign it and hope for the best. I would talk to somebody about it. So you can just include like the specific clause that you're worried about and be like, does this seem normal to you? Why do you think they're doing this kind of thing? And there might be cases where, the more experienced person says, "Oh my God, that sounds terrible. You should definitely stay away from that." Or other times there might be specific reasons, like, I've had several people ask me about the social security number thing, and that's kind of one of those things where it's like, well, it's technically necessary in some really extreme cases, but you probably don't need that. So if you decide that it's a term that you don't want to sign, I would just be very upfront with the publisher about that. You don't need to be angry. You don't need to be confrontational. Sorry, a question came in. I'll come back to that in a sec. So you don't need to be confrontational or angry or anything. You can just say, you know what, I'm worried about this clause for this reason, and I'd really like it to be changed, and you can just ask straightforwardly for the change. A lot of times publishers will just be like, sure, okay, assuming that you're not trying to, double your money or something like that. A lot of them are probably gonna just be like, okay, that's fine. Or they might explain why they think they need that particular clause, and then you can decide whether you think that their reasoning is justified or not. It's just important to remember, like, especially as a new writer, it's really easy to forget that the publisher has skin in the game too. You have leverage, and if there's something that you need to negotiate, you should remember that you have leverage, because in a typical situation, like, let's say they've read through a couple thousand stories to pick out a couple dozen that they want to publish. Picking your story out of there represents a lot of work. And they put a lot of work into trying to pick that story out, and they don't want to blow it over something trivial. So if you're asking for something reasonable, they're probably going to do it. If you're asking for something unreasonable, then they're going to explain why they don't want to do it. But in any case, just asking for it isn't going to hurt anything. You should ask. And so, yeah, so just remember that you have options. Remember that you have leverage. Remember that you can ask other people ahead of time. You can try to find out what's normal, what's not normal. And, a lot of short fiction contracts are very similar. Oh, another resource that you could look at is SFWA has some sample contracts on their website, or like model contracts, I think they call them. That, like, these are the ideal contract according to our standards. And so it has a lot of examples of what you would want and what you would not want. It's definitely a good resource to check out if you're a writer looking at a contract, or if you're thinking about publishing, which sometimes writers decide to do too. It's a good place to start for a contract. Let's see, just look at my notes real quick. Okay, so I think that was kind of the main thing for negotiating. There were some advanced questions that I wanted to talk through. Double back to a question I saw in the chat. Yeah, sorry, trying to figure out where the chat is. So somebody asked, some scripts to use if you need them. Hey, this term in the contract gives me pause. Could we change it to thing instead? I would like to negotiate term to better term. Do you have any issues with that change? Those are great, very not confrontational. They make it clear that you're, it's assertive, makes it clear that you're asking for something and why you're asking for it and that kind of thing. I'll glance back through the chat in a little bit because I think I might have missed a thing or two. And another thing is that sometimes what you want to ask for is, you're not asking for a different term, you're just trying to remove some ambiguity. Like, if there's a phrase where it makes it unclear if it's talking about this format or that format, just to make sure that it's clear. Those kinds of clarity changes the editors should be totally on board with, because clarity is good for both sides. When negotiating contracts, I have had a couple cases where I've had where I've asked for something, and I asked for it on the terms of, well, what about in this worst case where this happens? I want to make sure that it's that retain rights in my own work. And I've had the occasional publisher who will come back and say, oh, I would never do that. That's not something I would ever do. And that's actually not a bad response to get, because it has an easy answer in that if you would never do that, that particular thing, let's put it in the contract. Because if you're already not going to do the thing that I'm asking you to not do, then we're in agreement, and let's just make it formal by putting it in the contract. So it's, that can be kind of an easy launching off point. Sometimes they say that in a, well, I would never do that, so I don't need to say I would never do that in the contract. And it's like, well, if you were never going to do that anyway, there's no reason not to put that in the contract, right? Because it's not something you were ever interested in doing in the first place.
Okay. So get into some of the questions that people asked ahead of time. So this one says, contracts often have a clause saying that disputes that arise will be solved by a certain tribunal, say a federal court in the US. What does that mean for international writers, such as writers residing outside of the territory of the magazine publisher? Can such rulings even be enforced? Have you seen that happen? I have not seen a lot of legal disputes personally. I've not been involved on either side of it. Obviously, legal disputes happen, but they might not publicize a lot of the details. Such rulings can definitely be enforced when they're outside of the territory, but it becomes more complicated because you then have to deal with international laws and things like that, and can also frequently become much more expensive, which again, when there's not a lot of money involved, makes it kind of hard to really get into. But it can definitely be enforced. And again, a lot of the point here is to define the terms rather than really get into the legal dispute territory, because generally you don't end up going into court for short fiction things, again, because there's not a lot of money involved. Contracts expressly state that the interpretation will be according to the customs and laws of a designated territory, i.e. the state of Delaware. If the author is not from that territory, does he have to research such customs and laws? Yeah, that's pretty standard. Generally, the designated territory happens to be the state that the publisher is located in. So like my contracts say the state of Minnesota. I wouldn't spend a lot of time researching the customs and laws. Because generally the ones that are relevant to short fiction publishing they're not going to be significantly different from territory to territory, at least in the US. I generally wouldn't worry about it too much. The publisher generally states where they're located. That way, like say I've had to negotiate, or I've had to distribute hundreds of contracts over the last 5 years, and it would be a lot more complicated for me if I had to have them each be administered under different territories. Having them administered under the same one with the volume that I'm having to handle just makes things a lot simpler. But it's generally not something I would spend a lot of time researching. It might be a red flag, however, if it's a different territory than the publisher is located at, that might be a reason to ask some more questions. Like if I had a publisher and if I was publishing from the United States and I claimed that it was being defined under the laws of the Cayman Islands or under the laws of Switzerland or something like that, it would beg the question of why. And it would raise the question of, are they doing this to try to take advantage of something that would not be in the author's favor? But generally, I wouldn't worry about it too much, as long as the location makes sense. I did talk to, asked Marguerite Kenner a little bit about this. She's a lawyer. She's a co-owner of Escape Artists, who have several great podcasts. And she pointed out some other things about this as well, and that there's some kind of different terminology involving this. So there's governing law versus jurisdiction versus venue. So that defines whether or not where the court will actually hear it, which laws will be used to interpret it, and which state or country has control of a proceeding at first instance, such as where the lawsuit or arbitration would happen. So there's a lot of differences in all of these kinds of things that they might be slightly different depending on the contract. But again, in general, I wouldn't worry about that too terribly much because the differences generally are not gigantic. Okay, and then what kinds of negotiations should you make for audio rights if contract includes a podcast component? So generally, I would treat a podcast the same as I would treat another kind of publication, in that they should only be asking for the rights that they're intending to use. There should be a time limit on when they can exercise them. I mean, for a podcast, once the podcast is made, it could be out there distributing itself forever. So but they should be limited, say, after acceptance, they have to publish it within 2 years or 1 year, or whatever, kind of this, but very similar terms. The only thing I would really watch for is any kind of things. It tends to be something where if somebody wanted to make a podcast that is kind of like an add-on, I've seen things where we will publish this ebook within 2 years, and then there will be another clause that says, and we reserve the right to publish this as a podcast sometime in the future. So the problem in that case isn't the publishing in a podcast part, it's the sometime in the future part, in that you want every component of the publication to have a time limit on it. So if they publish it in an ebook now and then publish it in a podcast sometime in the future, that could interfere with other rights. Because I have seen some podcasts, they want to be the first one to publish an audio. And so if you had already signed an agreement that said sometime in the future, you technically couldn't submit to a place that wanted to be the first one to publish an audio. So I wouldn't negotiate podcasts much differently than regular ones. I would just kind of watch for those add-on kind of situations that are also an issue with other formats. Okay, looking at the other questions. What is something that would make you not sign a contract? Have you had to do this before? Please tell us about that experience. I don't know that I've ever gotten to a place where I would not sign a contract. I wish I had, about that example I had earlier with the alterations of the text, because again, I was very unhappy with that experience. But I also should have tried to negotiate that harder than I did. I would not sign anything, say, that asked me to give up copyright unless it was some kind of media tie-in that I was getting paid pretty well for. I would not sign anything that didn't have that lacked the time frame kind of situation. Things like that would definitely be no-goes. If they offered me less money than the guidelines said that they were going to offer, that would be a no-go for me. Things like that. I have pushed back on some terms before. Like I said, I've pushed back on, say, an obscenity clause where the publisher claimed that they were blameless if the story turned out to be legally obscene. But I've never had a case where the publisher, where I was unable to reach some kind of common ground with the publisher. It is possible that would happen. And personally, if that would happen, if it's something you really feel strongly about, I would just walk. You can try to find another publisher for your work. You can self-publish it if you need to. But I would not trust a publisher who would not meet me somewhere in the middle on something reasonable. Again, if you're trying to negotiate up the money, that's not going to work if they put it in the guidelines. But other terms they should, be somewhat flexible about. Can I negotiate? What is reasonable to ask for? Can I still negotiate if this is my first story sale? Yes, you can definitely negotiate if this is your first story sale. I understand that you're more nervous, you're not sure what the limits are, and you're afraid that you're going to screw up the deal. I wouldn't worry about screwing up the deal too much, as long as you don't get angry about it, you don't get accusatory. Just kind of, again, go with the playbook of I would like to change it to this term. This term seems a little too broad, or try to keep the language fairly neutral, but while asking for what you actually want. You can definitely negotiate. A lot of times the negotiations are, or say another thing I've seen negotiated is I've seen some contracts that demand that the author
provide a picture and a bio. And this is pretty common practice. Like a lot of publications have like the kind of picture that you'd put on the back of a book or something. But I have seen some places that ask for that in the contract, and then I've had some authors who asked for that to be removed because they didn't want a picture of themselves published. And that's fine. Like, I mean, the picture isn't a vital part of the publication anyway. It's just kind of a way for people to get to know the person a little bit. So I used to have that in my contract, and I've actually pulled that requirement out because, you know, again, it's not actually required for the publication to be able to go forward. And, you know, a lot of times people in that case might have a caricature of themselves, or they might have a picture of a tree that they really like, or, you know, themselves wearing a mask or something. It doesn't really make that much difference. It might be a little more strict, say, if you're having a book and then you have certain expectations. Okay. I think I'm caught up on questions that people asked ahead of time. I think I've missed a few in the chat, so I'm going to go back and look at them. Sorry, I'm starting to lose my voice a little bit. Okay. Regarding guidelines, could you speak a bit about simultaneous submissions policies and how to navigate them? Yeah, this is a little bit off topic, so I don't want to spend too much time on it. Simultaneous submissions, though, are kind of one of, so for people who aren't familiar, simultaneous submissions means when you send a story to one publisher at the same time that you send the same story to a different publisher. Some publishers don't claim that they don't allow that. Other publishers claim that they do. In science fiction fantasy, it tends to be not allowed. In, say, literary fiction, it tends to be more allowed. Diabolical Plots used to not allow simultaneous, but now does. Generally, allowing simultaneous submissions, if a publisher responds in a reasonable period of time, I don't think it really generally harms them to allow simultaneous submissions. I think the main argument against allowing simultaneous submissions is so that like another publisher doesn't swoop in and take the story while they're waiting. But, you know, if you're responding in a reasonable period of time, that's not generally a major issue. Personally, I would like to see more publications shift to allowing simultaneous submissions, as long as they also don't start taking longer to reply. So I guess that's what I'll say about it for now. Okay, I've seen submission guidelines that state that you grant them non-exclusive first rights by submitting your story. This seems immoral to me, but I am looking at it too negatively. Also, can a first right be non-exclusive? Yeah, I would agree that this is immoral if by submitting your story. So that part of the phrase is extremely important. By submitting your story, you should not be granting any rights by submitting your story. You should only be granting rights by signing a contract at the time of acceptance. Yeah, non-exclusive first rights does also seem self-contradictory in that, well, I guess not necessarily. I guess they'd be saying they were the first ones to publish, but that there's no exclusivity period. I guess that's technically possible. It's a little bit confusing though, because like, are they saying that nobody else can publish it before them? That seems to be implied by first rights, but then the non-exclusive. Anyway, personally, I would not submit there at all. Any place that asks for any kind of publication rights by submitting your story, I would not personally submit there. And that, again, is the reason why I don't list those on the submission grinder, because I don't want to encourage publishers to do that. What if a mega company like Disney buys your publisher? Can they ignore the contracts you signed with the original publisher, or do the terms you signed with the original publisher continue to apply? Do you need a clause saying the terms of the contract you're saying remain in effect no matter who buys the publisher? So yeah, so with the Disney situation, that's a pretty ugly one. I haven't seen the actual contract, but by what I understand of the contract terms, Disney has been violating them. a lot of times the contract will say something like, this contract is between the publisher and like its assignees and things like that. It'll kind of imply that the rights pass on. But the thing is you can't pass on part of a contract and only do the part that you want, because a contract comes with privileges and obligations. You can't take the privileges and skip the obligations. That's not what a contract is. So you can't say that we have the right to publish this story, but we don't need to pay you royalties that were agreed to in the contract. So like generally, if you're going to continue to publish it, then you also need to continue to do the obligations that are involved in publishing it. You can't just pick one or the other. Let's just see if there's any other questions in here. Yeah, and on the terms of edit, somebody said they had a preposition change that completely changed the paragraph. That's exactly why you want something in the contract about whether you're allowed to make alterations. Okay, I think that I'm caught up on all the questions. If anybody has any other questions, I think we're about at the end of my estimated time, but I think they said if people had questions and stuff that we could go over and it wouldn't be a big deal. Sislin, are you able to let people talk, or do we, if we just want to keep on going on chat, that's also fine. Okay, if anybody has any questions, feel free to unmute yourselves now, which you're now allowed to do.
Share a few more scripts for people on how to push back against bad terms in a contract.
Oh yeah, sure. Oh, and I realized that I never went back and showed the example contracts too. I could also share that. Was my mistake. I had it in my script and I skipped over it. Yeah, the ones, just to talk on that subject, I like the ones that were posted in here along the lines of, hey, this term in the contract gives me pause. Could we change it to this other thing instead? I would like to negotiate term to better term. Do you have any issues with that change? I would also say things like, I'm concerned about the implications of this, giving up audio rights if you're not planning on using audio rights, for instance. Would it be possible to restrict this to just the terms that you're planning on using? Things like that, or like say, I hear that you're asking about audio rights. I'm on board with audio rights, but I'd like some kind of term limit on that to make sure that I'm able to reprint it in podcasts in the future. I'd definitely say things like that. I would also say definitely talk about, phrases being ambiguous, saying that like there's two ways I could interpret this phrase. One of them is this, one of them is this. Could we rephrase the wording so that it's clear which of the two you mean? That kind of thing. Like say if they asked for a transfer of copyright to be able to publish, I would point out that it's not actually necessary for them to have copyright to publish, and I would get that completely rephrased in a case like that. And I would ask, like, this would be more standard phrasing. And in a case like that, I might go to like the SFWA model contracts and use those as an example to say, well, SFWA suggests this. Could we do something like this kind of thing? Again, it doesn't have to be real confrontational, but it's, I would withhold your signature if there's something that seems off about it. That kind of thing. Does that answer your question?
Yep. Thank you.
Okay. And then here it is. Go back to sharing again for a second. So how do I get behind this bar? Okay. I'll start with the bar pops up as soon as I try to go up to the bar. Okay, so here's some example contracts. These are fairly simple, fairly short. So this one is for an original work, like say at a magazine. So at the top you've had this contract is made between publisher name herein after referred to as the publisher and author name hereinafter referred to as the author. So this is pretty standard language. And then throughout the rest of it, they would say author, publisher, etc. Instead, so you normally would only have the name at the top. So up here is generally where, if you use an LLC or a DBA, this is generally where that would be applied. So like my contracts say this contract is between Diabolical Plots LLC, but then at the bottom of the contract, I sign my name because I am the representative of the LLC. So then you'd say the author grants permission for the publisher to include their story hereinafter referred to as the work. So again, that's another defining term, and says the exact formats in which it's going to be published. Notice it doesn't say a podcast or anything, because in this case there is no podcast. The author agrees not to publish or permit others to publish the work prior to the publication on the website or for a period of 6 months. So this is an exclusivity period here, a period of 6 months after publication, without the prior written permission of the publisher. So a case where you'd ask for written permission is, say if there was a best of anthology, a lot of times there's explicit exclusions for a best of anthology. Not too important with a 6 month period, because usually a best of would only happen the following year, and so it would probably be after 6 months anyway. But say if you had a year or 2 year exclusivity period, then there might need to be something carved out for best of anthologies. But even if there isn't, then written permission of the publisher. Most publishers, if they say like, hey, I've been contacted by, say, Ellen Datlow, and she wants to publish my story in a best of anthology, the publisher's going to be like, yeah, that sounds great. So just talk to the publisher in a case like that, and they're probably going to be okay with it. Author further grants the publisher the right to archive the work. That's pretty normal for like an online publication, because you don't want holes in your archive. Specifies how you get paid. Could be PayPal or check. This would be filled in with the actual dollar amount. This specifies the pay period. Here's a clause about the author. So this is a case where it was changed to be author approved image instead of being an image of the author, because it could be an image of, a tree or something. As long as the author's approved it, it's fine. And then I think this should be implied anyway, but it never hurts to actually state it. All rights not expressly granted by the author reside exclusively with the author. That makes sense. The publisher's only getting the rights that they are explicitly asking for. They say that they're the sole author of the work. Of course, this would need to be modified if it was something that was co-written by two people. That they're the owner of all the rights granted to the publisher. So if I sell first publication rights to this publication, I cannot sell first publication rights to another publication, because I don't have those rights anymore. So that's just saying that, they have the rights to grant what they're granting. It's not libelous, not a violation of privacy, not harmful to a third party, etc. Those are all pretty standard. Then indemnify the publisher against loss or injury if there's any breach of this warranty. So again, if the author plagiarized the work and then got sued because the author entered into this contract by misrepresenting the work, that would mean that the publisher should be indemnified against that, which makes sense. The publisher will make no alterations to the work text or title without the author's written approval in email or hard copy. So customary form and usage, again, that would be like paragraph indentations and trivial stuff like that. And the all-important time termination. If the publisher fails to publish the work within 24 months, all rights granted hereunder shall immediately revert to the author. And a lot of times they'll also say the second part, in such event, the author shall retain any payments made under this agreement prior to such reversion. So if I have already paid an author, but then I fail to publish it within 24 months, they keep that money. And that's fairly standard. Because, at that point, if you've already been paid, you've probably already spent it. You don't want to be coming back to the author or to the publisher and paying them back because of a failure of the publisher to do what they were supposed to do in the first place. Here's the author credit. So this would be like at the top of the contract would be your legal name. This would be where your pen name would be. So those obviously don't have to have anything to do with each other at all. Location of the publisher. Okay. So that's kind of all the stuff. Fairly simple contract as far as it goes. Then here's a reprint contract. So this would be more like say the long list anthology. So for a case like this, it would be something where I've contacted the author and been like, hey, I really like your story. I would like to publish it in an anthology. And so the terms are fairly different in this one. The pay is probably a lot lower generally because it's not first publication. First publication is where a lot of the money is. Okay, so some of the differences here, you'll notice that here it says non-exclusive. That's a big difference. So in the case of non-exclusive, so like say with a long list anthology, I don't care if they publish it again in between signing the contract and me publishing it. I don't care if somebody publishes it the same day. None of that matters. Would it be possible to share copies of these samples? I can write up some slightly altered ones. I probably want to strip some of the diabolical plots wording out of it. I mean, like the actual word diabolical plots out of that last one and stuff. And then let's see. Some mention of, say, that you can post excerpts of the story for marketing and promotion purposes. In this case, it says that it will not publish or repurpose the story in subsequent anthologies. So say a long list anthology, I would be reprinting a story, say in long list anthology number 7, but I couldn't like come back and automatically publish it in number 8 or do like a best of long list anthology without permission. I would have to ask permission. I would have to get a new contract for that. And, that's all good. But it does say that, say, I am allowed to do new editions of the anthology to correct, say, spelling. Because say if there were some spelling errors in there, then like Amazon might come back to me and say, we're not going to list this unless you fix these errors. I wouldn't want to be in a situation where I was not allowed to fix those errors because then I would not be able to publish it. So there needs to be some exclusions for that. Also say like, I've had some, like let's say there's a situation where I reprint a story by an author and then an author's name changes. Either they choose a new pen name or they transition or whatever, and they start using a new name. It is possible for me to like change their name in the anthology and without having to ask everybody's permission because the anthology is materially the same apart from that name, and that name doesn't affect other people. So it's like changes like that would be allowed. But I wouldn't like be able to remix the anthology, take 10 stories out of this anthology and combine them with 10 stories of that anthology. That would not be allowed. That's the kind of thing that's trying to exclude. Unless I asked for in a case like that, I could do it if I had a new contract. I would just need to ask for a new contract. And so again, in this example, the payment is very different. In this case, it pays 1 cent per word upfront and then pays a certain portion of royalties. So like in this case, when I get ebook royalties, half of those royalties go to the publisher, and then half those royalties are split between the authors, and they're split prorated by the word count. And so if they're so like a novella is going to get a larger share than a flash fiction story, etc., and those all get shared around. Again, here's the all-important time limit reversion. So yeah, and then the rest of it's pretty much the same. So I think that that's about all that I had, unless people have any more questions. I think we can wrap this up.
Would it be possible to share copies of these samples?
Yeah, I can share copies of these samples. I had already tried to strip some of the like diabolical plots language out of them, and I'll probably like remove like say that, but I'll get a slightly modified version shared somehow. I'll have to talk to Dream Foundry about how they if there's a way to do that through them or I can post it on Diabolical Plots or something.
We can work it out.
Yeah, we'll figure it out. That makes sense. Anything else before we go? Cool. Well, thank you everybody for spending an hour and 45 minutes listening to me jibber jabber. Hopefully it's been very useful to all of you. I really appreciate you showing up. Thanks a lot.
Thank you so much.